Okay, in this video we're just going to go over the kind of main concepts that you've learned in this class to help you prepare for the final exam. So my advice is that you watch this a couple times, let it sink in, and try to memorize what you can. So just to remind you that the legal system, and I made this diagram to try to help you, is just to remember that the system is part of this larger social system. And so the social system has devised or has come up with this idea of this particular legal system, which is called an adversarial system, in which the shared goal is also the shared goal of the criminal justice system, and that's to close cases. So police, investigators open the cases. The idea is that along that process, whether it's closed through the criminal justice system, right, and so in which you don't need to go to trial, because the person has accepted a plea bargain or they were shot. But the cases that don't get terminated that way then go through to the trial system, and we're going to see, that doesn't always work in the ideal way. But to try to just understand, every society can devise their own criminal justice or legal system. It doesn't have to be this one. In fact, there's lots of different systems in the world. And there's been many, many different types of systems throughout history. And so in Violence in the Word, what Robert Cover's really trying to get you to remember is that the United States, the colonies, were part of a legal system in Great Britain. And they rebelled, they resisted, they went against that law. And so from the perspective of England, they were criminals. From the perspective of our American government textbooks, we call them heroes. And so it really changes, the social construct. What crime is depends on which society you're in and which social group you're a part of. But on the other hand, in this colonial system that they devised, it's the creation of the role of the executioner, in this case the judge, stands in, and they're complying with this mob violence, The society, the group of people want to get revenge, etc., things that you would learn about in your crime and punishment class. And so they've constructed a system in which the judge is the executioner. They're the person who makes the final decision. And so what Cover is arguing here is that judges are complicit with this organized violence. This is a decision that people have made historically. So it's not a decision we all vote on today. But as long as we comply with it, as long as we go along with it, we're saying that it's legitimate. Otherwise, this person, and there's kind of, if you watch old westerns or even old medieval movies, or movies about the medieval period, they didn't have movies during the medieval times, you'll see a different system, and it's much more ambiguous, The person who is the judge and the executioner in that system could end up being hunted down by the person's family, and that would be what was called a just killing. And so, there's all sorts of different ways to think about this other than the one we have. But this is what Robert Cover means by the judge operates within a field of pain and death. They're either taking away somebody's life, they're putting them away for prison for life, or they're taking away their liberty for some extended period of time. And so, again, it doesn't have to be this way. And so some students have asked, well, what are alternatives? Well, one that comes to mind, is that, in the Christian ethic, forgiveness is the better option, not punishment. And I'm sure that there's other religious organizations that have similar kind of values. And those are just the religious ones, We could take non-religious, secular, other points of view. There's conflict resolution. There's lots of different alternatives to the system that we have. So it's first and foremost understanding that this is a violent system. This is a system of violence, and the judge operates within that. It's whether it's morally desirable or not, that's a different issue. That's not a legal question. That's a moral question, or that's an ethical question that would be better for a philosophical or a sociology class, where you were really just thinking about what's the ethical position of punishment. And they do have classes like that that you can take. But just to first understand that this is the system that organizes violence from a social point of view and assigns a person, says you are in charge of meting out this punishment. And so it's just like the story. The analogy is that it's like the story in the movie The Lottery, because they're using the word, the legal system, and the experience of people going through it, and violence organized the same way. And so the executioner is a social role that society has created. It's not a natural or doesn't exist in nature. It's something that we've created, and we go along with it. And so the process could be unfair, as it is in the lottery, and innocent people may be wrongfully convicted or executed, because again, that's not the goal of the system. The system is to close cases and to execute people, take away their liberty. That's the goal of it. So people can get caught up in that system, especially as we see later in this presentation, if society is unequal. And so everyone who complies with this, is saying that this is the system we all want to be a part of. For the people who resist it, so comes to mind the people who are arguing for abolition, for example, they're trying to help people understand that this system is biased, it's corrupt, it's illegitimate, and so you've got this tension going between resistance and compliance. One major reason why people resist the system is because this system is subject to interpretation with limits, and those interpretations come out not really in just the things I've shown you in class, like whether the law applies in this particular situation, and by law there I mean legislative act, right, the bill that goes through Congress, or whether the words of this law, this legislative act, apply to this particular situation and how. But the third way is through procedures that you kind of saw in the article by Dr. Chris Chapman, whether it's for dismissing a case, whether it's for qualified immunity, which says that government actors should not be liable for their crimes if they're operating within their normal way of performing their job. So police are included in that because they're government actors. Or whether it's because of the way that we assign liability. Who should be responsible? Should the employer be responsible for the employee? These kind of questions are things that come up in a case, and judges make those decisions as they interpret how Congress or the state legislatures have passed laws that apply to those situations. And so, one famous one that doesn't get talked about a lot is that Congress had passed laws about what judges could and couldn't do, and in this case it was to give a writ. A writ is a piece of paper ordering a government official to do something. So the judge signs a piece of paper, they send it to the taxman has to give you your refund because you went through the court system saying I deserve this refund and you didn't give it to me. In this case, Justice Marshall in Marbury v. Madison decides he doesn't want to sign the piece of paper ordering the government to give this man his job as justice of the peace. And so how does he do this? How does Marshall invent this power to say, no, I'm not going to do my job? He misinterprets the Judiciary Act, and some say he did it on purpose, others say he did it on accident. And what it does is it creates this new power of what's called judicial review, which you might have learned about in another class, but it's never mentioned in the Constitution. There's very little argument that anyone had any idea that he would be able to do such a thing like this, except for the Federalist Papers. And so there's one very particular, the Federalist Papers were written by James Madison and John Jay and Alexander Hamilton, and Marshall is kind of in this group of thinking, and so they want judges to have this kind of power, and so they interpret the law to give themselves that power. It's an interesting kind of development in U.S. Legal history, and it's very different than other systems. Most systems don't have this ability, and probably for good reason. Judges have a lot of opportunities to make mistakes. The other issue is that, as you saw, was with hearsay. So hearsay appears to be a pretty good rule, right? I mean, we don't want to allow in evidence if the person doesn't have direct knowledge or experience or have observed the thing that's in question that we're trying to prove. But what you see is not so much that that's how the rules applied. In some cases, somebody will be doubted not because they didn't experience or have knowledge of the issue, but by the way they talk, whether they speak like the judge, how they look, what their history was, right? There's all these other issues that come up that make it difficult for the hearsay rule to be applied equally. And then following that line, there's gender discrimination in society at large, so there's also gender discrimination in the courts. And so women feel they've internalized this bias, and so they feel as if they have to write longer opinions and cite to more cases, and so they do that. And so they end up working longer hours, they work more cases, they work differently than men do, and that has an effect on the legal system. And then another thing to think about is that over 90% of criminal cases are resolved before they get to the judge. So the judge is just signing a piece of paper saying the defendant has agreed to a plea bargain. So they're only really dealing with the remaining 10% that have been unresolved, where people are demanding a trial or have other issues that they want to work out. Maybe they want to challenge the evidence. Maybe it was obtained unconstitutionally, for example. But with those 10%, as you saw in the Dr. Chapman article, judges have actually made it harder for people to protect their civil rights through the judicial process because of issues like qualified immunity, essentially saying that police officers aren't responsible for their behavior when they're on the job, dismissing claims because they don't have the right kind of evidence or they were unable to get the evidence in a specific amount of time, so not letting juries make those decisions, but the judge making that decision. And again, failing to hold cities and police departments responsible. And so that 10% of criminal cases is not really being resolved either. They're being dismissed. And so you've got almost no cases are going through the ordinary way of getting through the legal system that you'd read about in an intro textbook, where this is the ideal situation. That's not actually really happening. So it seems, as I think about this more and more each year, as students are highlighting, over here you see wrongful conviction is 43% of, this is over 200 students. And then all these other issues, bail reform, DNA evidence reform, stop and frisk. I mean, these are all very good issues. I mean, they're things that are big problems in the legal system, and this left-hand side here about interpretation procedure explains most of those, right? The judges have so much discretion, so much ability to make these decisions that there's lots of opportunities for mistakes. Now this starts to get towards the malleability of law then, because there's lots of laws, right? There's the legislative acts, there's judicial decisions, there's the U.S. Constitution. Each state, there's 50 states, they all have 50, each has a constitution, so there's 51 constitutions. Even the holdings we have, like Puerto Rico and Guam, they have constitutions. So there's lots of different laws. There's thousands and thousands and thousands and thousands of laws. And those laws represent general principles, statements, right? The statement of law saying, you can't do this or you should do this. And then judicial precedents that are argued by opposing sides, the plaintiff and the defendant, in this adversarial system where they're going up against each other. So the judge then has to apply their interpretation of those two arguments. And of course, there's lots of arguments within those two arguments. And then that's to their own understanding, how they understand the law. So each judge is going to be different based on their education, their professional standards, their religious beliefs, their political beliefs, what they had for breakfast that morning. I mean, all sorts of things can influence how they think about this. But then they've also got constraints because they can be overruled. The appeal goes to more judges. Of course, this is all if you can afford to file an appeal and pay for your lawyers to do it. Now, lawyers and judges are also socialized, right? They go to law school where they're taught certain things, they're taught certain ways, they're taught how to think certain ways. They take tests that get them to think a certain way, just like you do in college, but very focused on the law. They have professional experience of how they get along with their peers, how they get along with other lawyers. And then there's rules of ethics of the practice that, they can get in trouble if they do certain things or they don't do certain things. But they also, obviously, judges and lawyers are the process of those getting in trouble. So they also kind of push boundaries to say, well, we didn't mean this in this situation. We don't want you to be in trouble for this thing. One issue that's kind of come up in the last couple of years in the news is when judges take cases of which they have money invested in that company. In paper, right, or in theory, they're supposed to not hear those cases. They're supposed to give it to a judge who doesn't have a financial interest in that case. Thousands of judges have not done that. They've heard cases in which they had a financial interest. And so other judges and lawyers have to figure out, well, what do we do? What do we do with these judges? Should they get their law license taken away from them? Should they be removed from being judges? Should they be punished in some other way? And largely they haven't really been punished. And so you can see how laws are not equally applied there. Now, the process of legal reasoning includes you have to find cases that are similar to the situation that you're arguing. Once you find those cases, you have to then look at the precedents that the judges used, the conclusions that they had in those cases, and then you're going to argue it's like the case here, that you should rule the same way you did judge in this other case, or you should rule the same way some other judge ruled in this case. I want you to rule like they did, and you shouldn't rule like the other side, what they're saying. They don't know what they're talking about. And then, of course, the other side is going to say the same thing. So then the judge has to make a conclusion based on all of those case precedents that are being brought before them, and they're being told, think this way, think that way. They have to make that argument. And then also, they have to listen to the counter arguments, what each side is saying about the other. And so if you look over here to the right, then, different people within the system are all looking at law and laws differently. They serve them differently. They're tools in some situations. They're coming against you in other situations. They seem above you and out of reach in other situations. And so your experience is really forming how you view this law, and that's why there's 3 different stories about what law is. It's based on your experience. Most of you show me, or you talk about before the law, you're describing a system that seems to be outside of your reality and that could come in any second and punish you, and that it largely involves paperwork and formal proceedings and people in costumes that we call uniforms. And so, this is pretty common for people who come from a lower economic and social background, is that you don't have a lot of experience with the law. Whereas people in the business sector, like Charles, they're with the law. They use it as if it was a game. They can afford lawyers. They have lawyers playing this out. They use what a lot of you would call loopholes, which are just rules that you can use in order to win your case. And then there's people who have experience in justice regularly or socially through the system and unequal power, and so law is a waste of time for them. Law is never going to be on their side. It's not going to be objective and fair. It's not like what the people say about before the law. It's not rational. It's not procedure. It's all rigged against them. And they have experience where that's the case. That, lots of situations with police brutality, for example, against African Americans, have given a good reason, right? That is reality for them. And so you've got these 3 different ways of seeing what law is, and then you put that with the malleability of law, and law is used differently among different people because that's the system. That's the way that the system is set up. So this has a huge impact then on how crime is constructed, what we think crime is, and how it's dealt with in our society. So again, we have an unequal society. It's very racist in many ways, and so it largely targets people of color, and particularly Black and Latino men. Now, this is all despite the fact, the reality, that violent crime is much lower than it was 30 years ago. Non-violent property crimes like trespassing and theft, in which there's no violence, no touching, are the largest percentage of most criminal acts by far, and that people who commit really terrible, heinous crimes tend to be wealthier white men, or at least middle-class white men. And so the system over here on the right is not really responding to the reality of the facts. Now, this couples with this very odd situation where, remember, only 10% of cases aren't resolving in plea bargains. And so detectives aren't closing those cases. And so you have to start to think about what's going on. Well, there's not sufficient evidence. And so why isn't there sufficient evidence? Well, as you learn in investigative function, in order to secure a conviction through the legal system, you need to take care of your evidence. It needs to be collected well, organized, recorded, and examined. And so one of the reasons why detectives aren't solving as many cases, among many reasons, right? This is not the only reason, but this is one reason. Another reason was because we have fewer and fewer detectives, and so you've got more and more, like one detective taking on more and more cases. The other issue is we've switched over much more to computers, so you're using computer modeling which requires a different type of person, right? The people who were detectives, who became detectives in the 70s and 80s, I saw recently in the news they're starting to retire, which might be a good thing, so that younger people like you all can learn how to use computers and use computer modeling to solve crimes. Much harder for those older folks to do it. Some were able to do it, but not all. And so a lot of evidence wasn't being collected correctly. It was getting lost. It's disorganized. There's errors in the recording process because of these changes. And then some of it, even though it gets through the whole thing, it's not examined well, right? It's human error. The detective just doesn't do a good job putting the pieces together, and maybe misses things. And so you've got some examples I provided of that in the Long Island case. The other issue to think about is judges have deferred to police. And so, there's two huge things that have happened since the 1970s. One is that the totality of the circumstances test replaced the two-prong Aguilar test. So it used to be that there had to be, when thinking about a Fourth Amendment claim, which is usually what happens here, is that the defendant is going to raise a Fourth Amendment claim that their civil rights were violated. It used to be that you had to provide a concrete witness, that somebody had to have witnessed the defendant engaged in criminal activity, and then they had to be reliable. So they had to be an actual human, and then they had to be a reliable person. What the totality test did was that it replaced that requirement for the two parts, and it said, no, we're going to look at the entirety or the totality, all the pieces of the criminal investigation, and we'll make a decision based on that. And what they've done is deferred to police, saying, well, unless we have evidence that the police have done something wrong, and you can see that's like that healthcare example, unless the person can prove that the other side did something wrong, then we're going to side on behalf of the other side, of the people, of the police in this case. The other issue is that the reasonable suspicion, which many of you know from popular television, replaced what the Fourth Amendment says. The Fourth Amendment doesn't say anything about reasonable suspicion. It says probable cause plus a warrant. And so you get a warrant from a judge because you can show probable cause. Going back to the Aguilar test, it's because you're going to have evidence, and it's going to be reliable evidence. In other words, it's not going to get thrown out because of the hearsay rule. But that's been replaced. So the kind of the things you needed to have in court have now been replaced by this much more police-friendly reasonable suspicion. The police officer just has to have subjective reasons for suspecting the human being, and then they're going to be judged based on the totality of the circumstances. So, as you see, this has given a lot of power to police officers, despite their complaining, and it's probably not helpful from a judicial or a legal system point of view, unless, again, right, the goal is to close cases. A lot more cases can be closed this way, but you're going to lead to wrongful convictions, unjust arrests, plea bargains, all these other problems that are going to be created because of this. And then finally, you really have to start thinking about, crime as it's defined is always subject to ongoing debate. So right now, in some states, abortion is now a crime. In some states, marijuana possession is a crime. At the federal level, marijuana is a crime. It's possible abortion could be a crime again. It used to be a crime, now it could be a crime again. Same-sex marriage has been a crime at the federal level, and it could be again. There's lots of cyber crimes that you might not think about. A lot involving how you view and share information, right? Sharing somebody's Netflix account, that could be a crime. It technically is a crime. But it could be prosecuted depending on how people feel about it. Digital currency is often used in criminal acts, and so how you use that could be a crime. There's all sorts of debates around this, right? And so crime is socially constructed. It depends on kind of who's in charge and how they feel like implementing it. And so the other thing that tends to lead to this then is that white men voters tend to like the tough on crime language, and so in politics, when they start, we're going to go after these criminals who, as you see, have disproportionately been black and Latino men. So this is now leading us to this problem of unequal power. And so here you have people resisting, we have to resist separating the criminal and legal systems from social systems in general. We have to see, well, there's unequal power in the social system, so there's going to be unequal power in the criminal and legal systems. There's going to be the same amount of discrimination, if not more. Now, remember that the system is based on this idea of prisoner's dilemma. If you win, I lose, right? That's what we mean by a zero-sum game. And so the main goal is to produce winners and losers in order to close cases, right? To close the case, you're guilty. If it's left unresolved, that means you're not guilty. Now we lost on the criminal justice and legal side. And so this is this unequal power from the very beginning. And so we see power as domination as an exercise that requires compliance. You must do what I say, or I'm going to give you probably a violent consequence for disobedience. And so this doesn't matter if you're innocent. It doesn't matter if the process hasn't been followed. And the legal system has largely given a lot of leeway for police officers and other people in the system to behave this way. Now, on the other hand, you have civil rights, right? You have these laws that protect you, and so they can be a form of resistance when you've been the object of unfairness and injustice, and so you start demanding your rights. But what you'll find over time is that those who are dominating, they say, okay, we'll make reforms to the criminal justice system. Now, is this going to change much? No, because they want to figure out how to keep their domination in other ways. They're trying to control those social groups. So it's important in this study as criminal justice students and as liberal arts students to study the patterns of these unequal relationships over time and in different areas, because it helps us prove the law that crime is socially constructed, that it changes based on who we're talking about and where we're applying it, and then helps us understand that the most powerful decide what a criminal act is, and the less powerful don't get to participate in that process, which is itself unjust. That's not an equal situation, and so you've kind of got this unfair situation altogether. So Charles Lawrence is really trying to help you understand this as talking about the word as the articulation and validation. So people experiencing this injustice are trying to express it and getting people to say, you know what, you're right, this is unfair, and we should do something about this whole system, not just a reform, but we should try to change the unequal power relations. And this is the struggle against dehumanizing people. So when we say people are lesser than, they're not equal then, we're dehumanizing them. We're not giving them equal status. And so now you see, or should see, that the legality narrative resist the law or against the law is referring to this person's belief that law is not objective, it's not fair, it doesn't act automatically, it doesn't appear out of nowhere to help me, it's not there to find the truth or to protect and serve, but instead it's targeting vulnerable people, and it's doing it so on purpose, and it's doing it, even though it doesn't have to, and this is the opposite of the before the law narrative. And so it provides contradictory evidence that before the law perception is not real, right? It doesn't apply to everyone. It's not the only way. And so law is not one thing. There's lots of different ways of experiencing the law. Now this leads us to then understand how powerful domination works itself out in society and what we consider to be crimes and not. So if you look at the January 6th insurrectionists, and notice that we have a different word, right? So some people say some kids break some windows during a march, and we say that's a riot, right? That's a criminal word we use. Some white folks do the same thing, and they're called protesters. But then when they invade the Capitol, then they become insurrectionists, right? So we have different phrases that we use based on who we're talking about. And as you can see here, these were largely middle-class white folks, men, who, really committed what most people would have called an act of terror. Certainly if it wasn't white men, I think that's what they'd be charged with. But think about what these people believe. And so what they're told is that they're naturally superior to other people, that this is their country. And so that's why their phrase, "you will not replace us," the election was stolen, they see immigration as a threat, because they think this is their country. And so the reason we need to study this and other mass acts by white men in particular is that it helps us better understand anti-black violence. It shows us what's going on here, it proves that it's real, and because this system is unjust and that threatens all of us. At some point you could get caught up in this unequal power system. Now, this group of people, unlike many of you tend to see sovereignty in the old medieval sense, that we are all equal, we should all follow the law, it's all good for us, and as if we had a king and everyone was equal under the king, and so the law is the king. It's a natural thing for you to believe because you were taught it in your K through 12 education, right? So in junior high, high school, this is largely what you were kind of taught. As you get older and you start negotiating the world, you might work towards the compact or the social contract idea, where sovereignty is shared among those who are a part of the contract. However, those who are in power, and wealthy white men and middle-class white men, tend to view sovereignty as good advice. It's not required, and it only applies to the minority, those who don't have property, those who don't have jobs, or have lesser jobs, right? Those who are of a lesser or different position than them, and for them, they just get to make decisions, and it's their lives are guided by reason, and so they believe that their sovereignty is individual. They hold it individually. They're above the law. They're not part of it. They're entitled to their own self-government, and so if that's threatened, they have the right to insurrect. Now, you should be thinking, this sounds a lot like the same thing that Cover was saying about the founders and when they rebelled against the Great Britain system. And it's the same belief system. And so again, they were taught to have this belief, and so it's not surprising that they have it. You can also see this in Charles, right? As a businessman, he's comparing it to a baseball game, and so he's with the law. So law is something he can use whenever he wants to win, but it's not something that demands that he behave a certain way. It's not a moral thing. It doesn't apply to everybody equally. And then finally, you just want to remember, judiciary is not one thing. It's a label we use that describes many aspects of the U.S. legal system. And so I list them here to help you kind of get a better idea. And then you want to compare that over here to these statements that I've said throughout this presentation. And then ideally, like I did in the video, you want to refer to your course materials, right? So give examples from your readings and your activities that help me understand that you really get it. You totally now get it. This is what is the main point of the class, and you'll make me feel better about sending you on to the next class.